Okay, let's go.
Good afternoon. This is the Board of Appeals, Town of Hempstead, February 7th, 2024, 2 o'clock meeting. Mr. Chairman, do you have any opening remarks?
How many people in the audience have not been here before? Okay, so the way we process cases is as follows. First, we request adjournments, and we take those applications first. Ordinarily, first time a case is on, someone requests an adjournment, we grant it. Then we will start the calendar call for the cases that are not going to be adjourned. The way we proceed in that fashion is the applicant makes their case. If there is any opposition, we give the opposition the opportunity to present their objections, and then the applicant sums up. Everything here is archived. It's videoed. We have a court reporter so that anyone who wishes to do so can review the proceedings later on. Right?
Okay, we have a few applications for adjournment.
Okay.
First one being 9224 Inwood, 105 to 107 Doughty Boulevard. Variances, height exceeds number of stories. Construct 3-story office building. Waive off-street parking. Demolish existing building. West Side Doughty Boulevard, 151.14 feet north of Bayview Avenue.
Good afternoon, Mr. Chairman, members of the board. Upon our review of this application over the last couple of weeks in preparation for this hearing, my office noticed that there was a variance request that was not picked up, and we've gone back to the building department. We'd be looking for an adjournment somewhere in the vicinity of 6 weeks.
Where would that put us?
We have March 27th at 2 o'clock.
That works.
It's up to, he knows what he's doing. Okay, we'll grant that. March 27th, 2 p.m. You know what you have to do. You'll have to go back to the building department, et cetera, et cetera. Okay, thank you.
Okay, next case, 9324 Levittown, Satish Kumar, special exception for proposed religious use in existing building, waive off-street parking, also known as 5 North Village Green. It's a defective notice to be adjourned.
Michael's absent for the applicant. The mailing was defective on here. We requested an adjournment of about 6 weeks.
You must have been talking to Mr. D'Agostino. Do we have room on the March 27th calendar? No.
27th.
Next date?
April 17th at 2 o'clock.
Thank you.
You're welcome.
Someone else here on that case, right?
No.
I believe you have to update the sign. Probably had to put a sign on the property.
I'll check with the zoning law.
Okay,
Whatever they want me to do.
got it. I knew you
Okay.
would.
Next.
Last application for adjournment, case 9424 Belmore, SDL Belmore LLC. Variance exceeds number of stories. Construct 3-story apartment building, 28 units. Demolish existing building, also known as 1373 Belmore Road.
Good morning, or good afternoon.
Is there anyone else here on the case?
Yes, Mr. Chairman.
Okay. Okay. Go ahead. Reason for the application, young lady.
Yes, I'm Nicole Tuffarelli. I'm a North Belmore resident at 1491 Horseshoe Drive, and I'm requesting an adjournment in order to meet with the applicant and discuss the proposed changes about the subject property.
April 3rd,
We have received a substantial number of objections in this case, as a result of which we're probably, if you can't resolve your issues, we're probably going to devote the better part of a day to this application. And the earliest that we can accommodate is going to be April 3rd. Is that it?
Correct.
9:30 in the morning, and we're clearing the entire day so that you will have an adequate opportunity to present. And this is going to be marked final. There aren't going to be any more adjournments. Pardon? Okay? April 3rd, 9:30 a.m.
Mr. Chairman, if I might, Daniel Baker, Greenberg Trower, for the applicant. We don't object to an adjournment, of course. We would have preferred something a little sooner, but I understand the board's position, certainly, and we will speak with
We would have liked,
and any other.
we would have liked to accommodate, however, our calendar is such that we really can't put a case of this type on any sooner than April 3rd.
I understand, Mr. Chairman.
Okay?
Again, my point simply is that we will do our best to
Okay.
send the comments.
And hopefully you'll be able to resolve a lot of your issues, or at least clarify them before that date.
And you have to probably change the sign. And anyone else here? Hold on. I just want
In
to
a
say to
minute.
the people here, you won't get a new mailing notice because you're here. This is your notice of when the next hearing is on the matter. There's not an additional mailing. So if there are others here who, if there are people who aren't here today and you know, you've been speaking with them, you can let them know, number one, about, you're going to work with the group. You have the copy of the sign-in sheet?
I don't, but I'll
So get that, give your information if you will, so that everyone who wants to be involved in the process of, with the community can do that. Anyone here who knows of someone else who's not here, they will not get a new mailing, right? So that's the next date. They won't get a mailing about whatever the community meeting is, so you guys have to keep one another informed, and then you'll change the sign to reflect the new date and whatever else you gotta do.
Yes, ma'am.
May I have permission to speak for one?
Certainly.
Give your name and address for the record, please.
My name is Joyce Litwin Zimmerman. I'm a resident in East Meadow. I've been a member of this community for over 33 years.
I think you can pull it out of that if you want to take it. It looks like
Oh, thank you.
it kind of just snaps
Which
out.
community?
Thank you very much. I'm here because I am in favor of this proposal.
Okay.
I am.
Ma'am, with all due respect, you'll have the opportunity
Okay, I just want
to
you to
make
know
that
there are people in
presentation
favor
at the
of this.
appropriate time.
Okay, we
Okay,
understand.
thank
you.
you.
I think we've
Is that
received
Mr.
information on both.
Regano?
Regano.
May I hand you this letter?
You may. We take letters. Pardon?
Oh, thank you very much. Thank you for hearing my comment.
All right, we'll take
Welcome.
it into evidence and mark it.
April
before
3rd,
the board
correct?
gets
9:30?
April 3rd, 9:30 in the morning.
Okay, thank you.
Welcome. Welcome. Have a good day.
Okay, our first case, 8624 to 8824, East Meadow. Mercida Ebrek and Ravi Beldeo, mother-daughter residence,
My,
second
things-
kitchen.
things have calmed
Variance,
down.
rear yard, construct addition attached to dwelling. Variance, side yard, maintain AC unit attached to dwelling,
Okay.
also known as 1384 Diamond Lane.
Why did they even come? Deal with it. Okay?
Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I have
Please
to
be
ask
seated
this.
and state your names and addresses for the record.
I have to ask this.
Good afternoon. Good afternoon.
Just a minute.
Sure.
I have to ask your client a question, if you don't mind, because I may have to recuse myself from this case. All right? Mr. Baldeo, are you related to a Dr. Philip Baldeo?
No, I'm not.
Okay. Present your case.
Gennaro Cozzolino, 2125 Deer Park Avenue, Deer Park, New York, 11729. Good afternoon.
Do you expect your client to testify? If so, he should be sworn in.
We were sworn in.
Oh, okay.
Good afternoon, Mr. Chairman, members of the board. Gennaro
afternoon.
Cozzolino for the homeowners, Mercida Ibrick and Ravi Baldeo of 1384 Diamond Lane, East Meadow, also known as Section 50, Block 573, Lot 18, located in the B zone. We are requesting relief from the board to build a side and rear addition for parent-child use and maintain an AC condenser in the side yard. The addition requires a variance for rear yard setback, requesting 13.64 feet from permitted 15 feet, a difference of 1.36 feet. The AC condenser requires a variance for side yard setback, requesting 2.64 feet from permitted 5 feet, a difference of 2.36 feet. We're requesting permission from the board for a parent-child use for installation of a second kitchen in the new addition. The owners, Mr. Ravi Baldeo and Mrs. Mercida Ibrick, and their 2 children will be occupying the main house, the primary residence, while Mr. Baldeo's parents and his grandmother will be staying in the new addition, the secondary residence.
Mr. Cozzolino, where's the rest of the family?
His wife and his
So
father.
that is, say your names if you don't mind. Say it again?
Lal
Okay, Lal,
Baldeo.
okay. Okay, great. You could sit back down. I saw you signed in, and I didn't know where you were. Go ahead.
All parties have read and agreed to the requirements of the mother-daughter fact sheet. There will be only 1 electrical meter, 1 mailbox, 1 doorbell, and they will be providing 4 off-street parking spaces where they only need 3. Thank you for your time with this matter.
So, Mr. Cozzolino, let's just go through it. How many doorbells, how many mailboxes, how many meters?
One doorbell, 1 mailbox, 1 electrical meter.
Okay, and did you explain to your client from the mother-daughter fact sheet that
Yes.
if this were granted, it's unique to him and his family, and that in the event the premises is sold or it ceases to be used in that way, it must revert back to a single-family residence?
Yes, it has to be reverted back to 1 family.
Okay. And as you know, I'm sure, that whenever we have an application for an immediate family residence or a mother-daughter residence, the Board of Architectural Review reviews the application to determine whether or not the dwelling is suitable to be used as a mother-daughter immediate family residence, and whether or not it is suitable to revert back to a single-family residence upon the cessation of that use. From time to time, the Board of Architectural Review makes recommendations such as remove that door at the top of the stairs, remove those hip walls, et cetera. Things that usually would make it more like a mother-daughter use and less like a 2-family use.
Correct.
So in the case of the application before us, and I say this, I read this so that it's on part of the record, the Board of Architectural Review determined that it is suitable to be used as a mother-daughter immediate family residence, and it is restorable to a single-family residence upon the cessation of that use. It made no recommendations as to any changes that it felt necessary for the premises to be used in the fashion that you've applied for. Okay?
That concludes your case.
Yes, sir.
Any other questions from the board?
1 second, Mr.
Okay.
Thank you. I'm looking at Google Earth for 1384 Diamond Lane, and it looks like there's an extension on the house already.
That is a deck. That is a deck.
It's
A rear deck that's being removed?
No, not a deck. It looks like a whole, would you mind coming up and I'll show you,
Yeah,
please?
yeah, because I asked you that here, these 3 questions I asked.
This is the addition. Here's Diamond.
Mailboxes right there. Doorbells, that's
Yeah, it's all, look,
Looks
it's
like it's
right
already
here.
pumped in.
Is it?
Housekeeping units, water, electric, doorbells, and mailbox.
1384, right?
I asked him already.
So this whole thing is coming off too? Does it show that on the plans? Yeah.
I have a covered deck.
On the record. So let the record reflect that the representative for the applicant approached the bench to help us understand the plans and where the proposed demolition is and the proposed new addition would be constructed, and also is informed the board that they're filing an application to legalize and maintain a basement that has a bathroom in it and is otherwise finished for a usable space. That will be, we will be receiving shortly, and we will hold this on reserve. With that application, copy of the application, we'll get a copy of the amended plans that show what's in the basement, and we'll hold this on reserve until such time as we get that, so that we do our deliberations with an accurate amended copy of what's in the basement along, and make sure when you do that, might as well look at the rest of it, make sure that's all
Yes.
just what's there now.
Very good.
Go ahead, sir.
Okay.
Is that your case then?
Yes, it is.
Should be, since you already said we're going to hold it.
We have to.
I know. All right, thank you.
Thank you.
I assume there are no other questions from the board. If not, do I have a motion? Hello?
I move that the hearing be closed, the matter be placed on the decision calendar. Mr. Cozzolino, you and your client, and everyone else who signed in on the matter will receive a copy of the board's decision by mail once it's ready.
Second.
All in favor? Any opposed? Any abstentions?
Next case, 8924 Near Island Park, Thomas Massey.
Subdivision.
Variances, subdivision of lot area, front width from and on-street line to front setback line, maintain dwelling on a lesser lot, remove portion of existing dwelling and garage, also known as 200 Block Lane, and case 9024 Near Island Park, Thomas Massey. Variances, subdivision of lot area, front width from and on-street line to front setback line, construct dwelling with garage, west side of Block Lane, 225 feet south of Kent Boulevard. Please stand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Please be seated and state your names and addresses for the record.
Good afternoon, Chairman and members. Christian Brown, McLaughlin and Stern, 1122 Franklin Avenue, Garden City, for the applicant.
Emilio Sousa, 18 Corin Avenue, New Hyde Park, New York, 11040. Architect for the applicant.
Anthony Massey, 5 Milton Road, Babylon, a brother of the applicant.
Good afternoon. So this is an application to subdivide an existing parcel located on Block Lane in Island Park with the goal of renovating an existing dwelling that is currently located at this, on this site, 200 Block Lane, renovating that existing dwelling and then constructing a new dwelling on the subdivided lot. If you look at the composite subdivision plan, you'll see there's a Plot B and a Plot A. Plot B would be the newly created lot for the new dwelling, and Plot A would be the maintained dwelling. Both of these parcels would be 5,128, well, correction. Parcel A would be 5,122 square feet, and parcel B would be 5,128 square feet, both with 40 feet of frontage, but they're both 128 feet deep, and they go out to the water, so that's what's behind the house. The goal of the Massey families, represented here by Anthony, is to keep the property in the family. Right now, the house that's on the property is occupied by Mr. Massey's brother and his young family. The house is, as Mr. Sousa can tell you, is not in good condition and is not optimal for raising a young family. So the idea here would be to renovate the existing house, actually make it smaller by taking off about 600 or so square feet. More than that. Can you, how much would the house be reduced?
We'd be reducing the existing house by 1,163 square feet, which translates to cutting off 20 feet in width.
Wait, the house or the land?
The
No, the
house.
existing house, we're going to take off
1,163 square feet, or 20 foot 5 inches of width of that existing
By
house.
50 some odd feet.
And the goal would be then to make it comply with all the zoning regulations, even on the smaller lot, make it a smaller home, and Mr. Massey's mother will then live in that house. She's a single elderly or older senior citizen, let us say. And this would be an optimal place for her to live in about a 1,300 square foot footprint, correct?
Correct.
And then,
Now,
yes.
Didn't this property come before us?
No, the neighboring property came before you.
Which one?
It's on your map as McCool Hostens, lots 124,
For a
126.
40-foot.
Correct.
Keep going.
So the goal here would be then that Mr. Massey, who now lives in the house, will construct a new house for him and his family next door to where we hope his mother would live, also on the same size parcel. Both of the houses are fully zoning compliant, other than the lot size and frontage requirement. So it doesn't need any other variances.
But didn't Mr. Massey come for that one called McCool or whatever?
Mr. Massey, if I recall correctly, he had come into ownership of that lot and sold it to McCool,
But
I
wasn't
believe.
it before us for him? I remember his name on this, I believe I remember his name on creating the building lot.
Only, I think, as the former owner. That lot was owned by a number of different people in the neighborhood, and then it was lost. It was lost by one family who lives across on Island Parkway for taxes. And I believe that a tax lien purchaser purchased it, and eventually, I think Mr. Massey owned it at one time and then transferred it to McCool. Is that right, if you know?
It was purchased, it was a very narrow piece of ground.
Purchased by whom?
I'm sorry?
It was purchased by,
Yeah, I believe it did.
wait, just.
Recall what happened. The property was lost in a tax lien sale. I believe Mr. Massey purchased it from the lien holder.
Okay,
He then sold it to McCool Hostens. And they were the applicant. I represented them. They were the applicant on the application to construct a home on that lot grouping, 124, 125, 126, 127, which the board granted in 2022.
wait, I only have their names on 124 and, oh, I see,
They
it's
see it.
depth-wise.
It's fun, yeah, there's two tax lots that are at the end of the property in
Have
the
they,
water.
have they constructed a home on it?
I believe they have, yes.
Mr. Massey would know.
They constructed their house. It's under construction as we speak. So that was granted on 10/31/22 under case 22, I'm sorry, case 794 of 2022, to build one house on essentially an identical sized lot.
Mr. Brown,
Yes.
when Mr. Massey owned that property, lots 24 through 27, did he have any ownership in the lots now before us today?
Yes. He lives on the subject property.
No, but I mean, did they come in common ownership? Are we looking
No.
to subdivide it off of that group?
No,
too?
no, what happened was the neighboring lots, as I recall, originally belonged to, one of the neighbors, I believe it's either what is 135 or 137 on your map that fronts on Island Parkway.
Okay,
That owner owned the McCool lot grouping as a vacant lot. I guess they used it to go down to the water. They didn't pay the taxes over time. There were deaths in the family, I believe, and the property was eventually lost in a tax lien sale.
The lien and so
It was
on.
bought by Mr. Pekich, who's a tax lien buyer in Nassau County. He transferred the vacant lot to Massey, I believe, and but Massey never used it as part of his house. He just bought a vacant lot.
But did he come to own it while he owned lots 122, 23, and I can't see the lot number of the other one?
I think he did. He then sold those, but it was just a vacant property. He didn't use it as part of his house. He then sold it to McCool, who came here for permission to build on the substandard lot, which you granted, and there's now a house under construction there.
So
Was McCool the contract vendee then?
No, I think McCool owned it when we came here, if I recall correctly.
I feel like Mr. Massey's name is on it, but I don't really.
One of
So
the reasons
tell us-
you may remember that is because we went through an extensive testimony on the chain of title to explain how this vacant piece came into their possession. But I'm 99% certain that that McCool was already in ownership when we came here.
But, so we don't have an issue of it having merged under state law with the McCool property and still being
No.
some purpose?
The town of Hempstead does not have a merger clause in
That's why she
its
said
code.
state.
And under the common law, the property would only merge if they were used in conjunction with each other as one overall parcel, which they never were here.
Okay.
So in any event, that is an extremely similar application. Actually, there were some variances granted for the house that's now going up there. Neither of these houses needs a variance. If you look at the map, you can see this is a unique area. This is a unique block lane. It fronts on the water. If you could just go down Block Lane, you can see that Lot 116 is a 40, Lot 118 is a 40. Then you come to Lot 120, which is a 60. Then the subject property, which we're proposing to make into two 40s. The next parcel is a 40. The Flynn parcel, Lot 148, 149 is a 40. Then you have Rizzo at 150, 151, which is a 60, and then the final parcel on the street, 140, 143, up towards Kent Lane, has 45 feet of frontage. So the majority of the lots, all but two, are 40s or 145. So it's entirely within the character of the area. The houses fit on the property without the need for any other variances. This is a sort of a unique, as I said, not isolated, but it's its own little neighborhood on its own little street here with access to the water. The goal here is not to make money as much as it is to turn this kind of dilapidated house that's no good for a young family into a nice residence for Mrs. Massey and to build a new house for the family next door. And that's really that's the goal of this application. So I also know that both the Masseys have spoken with the neighbors. I can represent there's been no objections from them, including Mr. Culhane, the McCools, Flynn, no objection to the application as proposed. Yes.
Can I ask you, Mr. Brown, I seem to recall when we had that other case, something about this straight, like, this is not a road maintained, this doesn't need a 280A thing?
Well,
And also, compound question here, and also, I feel like there was something about the people were all using the town land. If that's the case, or some portion of it in the front, if that's the case, I just want to make sure that this depth, for example, 128, does not include any town land.
There's no town land. The street is,
I don't,
it is on a map. It's a mapped street. It's never clear to me whether it's considered private or it's a mapped street that's sort of, I don't know how else to say it, kind of falls in this no man's land because people do put their garbage on either corner, but it is plowed by the town.
How wide is it?
Can you say how wide it is? About it is 15 feet. And we
that
discussed
standard
that.
width? Oh, well, you said standard width. I never saw
Well,
15 feet.
Well, 15 feet is the minimum under state law that would be deemed safe for access.
For double lanes or one lane? Like, I have a 20-foot street by my house, and it's inadequate. Like, I think it's inadequate. It's not compliant.
Right, well,
Two cars can't pass.
right, 30 feet is the standard width of a street.
Okay.
15 feet under the town law is presumed appropriate for access.
Under 280.
Correct,
So
correct.
does the town plows it if it's snow? What if it needs to be repaved? Does the town do that, or is it not paved?
It's, you want to speak?
That was,
Name and address,
that was
yeah.
just repaved within the,
You gotta speak louder.
Anthony Massey. They just repaved that whole road, so it's all fresh blacktop now.
Wait, are you
whoever-
Thomas Massey or?
No, I'm Anthony Massey, Thomas's brother.
Oh, brother, okay.
Yeah.
Go on. So the town paved it,
No, the neighbors didn't do it. They just redid all the sewers in the whole area.
the town?
I suppose so, yeah. Yeah, the town, they teared up all the roads in the town, and that road now is freshly paved.
Right, I just want to know because it's relevant to our inquiry, whether or not it's a town road. So the
They've never plowed it, and it has been maintained by the town as a roadway. This comes up a lot in Island Park, where you have these roads that are on a map, but sometimes the town says that the town doesn't own the fee to the roadbed, but the town still has paved it and maintained it, even though it doesn't own the fee. Yes, it was part of a larger municipal project, correct? And all the houses connect to the sewer system, and we're able to get building permits without any, yeah, the standard utilities are available. As I said, the McCool House is under construction now pursuant to a grant from this board, and they've been able to build the house just as you would on any other street. So it is a little bit odd, but the town treats it like a public roadway. I think the only difference is that in the town records, the town doesn't have a record of ownership of the land itself, which there are a number, as I said, in Island Park. California Place South and North, same thing. They're fully paved streets maintained by the town, but the town says they don't own the actual street bed. I believe that's the classification that's, let me put it this way, that's my interpretation of what the status is. Right. Correct. But they do maintain it, yes. And they do, yes. Correct. Because I guess when the dedication maps were filed way back when, for whatever reason, parts of these streets weren't on the dedication maps, but they exist, and they're paved, they have curbs, and people go down them, and so they are public streets, but the fee ownership I guess, was never formally vested in the town.
Because I think I inspected this other property before, and, I mean, maybe you can tell me. If I recall correctly, it's a very narrow street, and there were I think there were gates, like chain link gates at the ends for the neighbors to keep it closed so no one else can go on it. Is that true?
That is true. I don't know who put up the gate years ago, but I think that's been removed since. I think one of the neighbors just didn't want through traffic for some reason.
Right, hence it's not public. I don't want
No,
the
they were
traffic either. Let me put up a gate.
They were complaining about people driving too fast, so I don't know.
I have the same problem on my street.
Don't ask me how it happened and how it ended up staying, but,
So the gates aren't there. I think they were on both ends. I'm not sure.
no,
I remember
just
it
the
on
one.
the Warwick end.
Just the one gate is in the middle. I can't really explain.
In the middle of the road.
Yeah.
So if that gate's closed, how does the town,
The gate's always open. The gate's never closed, ever.
I don't think that's legally proper. See, these
Agreed.
streets are mapped, and they are public rights-of-way. Regardless of who owns it or maintains it, they are public rights-of-way that are on maps. So if that's being done, that's really, that if it were to be done, it would not be proper.
yeah, I saw it when I did the other. So is it you or your brother who owns the property? Which one was it? Was it you planning to live in the house and your mom in the other, or?
No. This is all my brother's property.
just a representative.
It's our mother we're trying to get better housing for.
And he's gonna be the one in the other dwelling if it was approved?
I'm sorry?
And
Yeah, correct.
So that's the application, unless you have any further questions.
I just want to take it.
Sure.
Mr. Brown, for you, I just asked Mrs. DeResta to go to the Highway Department with the, and she said that the Highway Department said it's a private road.
I understand, that's the, I don't want to get in a legal, excuse me. That is the terminology that the Highway Department uses. This is my understanding just from common sense and looking at maps,
That
if I,
doesn't
if I
apply.
could use it. Again, the town says, uses the term private road for a road that it doesn't own the fee title to.
Okay.
But, as you just heard, they plow it, they pave it, and people can access it, and it's on a map. So I don't think it's a private road. I think it's a public, it's a right-of-way. They may not own the fee to it, but there's no, you can't restrict the public from accessing it. And they do give it a level of maintenance.
Which they probably should not, but I'm not gonna.
If they were to take the view that they don't own it and it's not part of the road system, it's essentially a driveway,
Right.
that the fee is vested in the abutting owners, then yeah, they shouldn't be doing that. But we get these situations here, the fee is not vested in the abutting owners. It was put on a map by a developer at one time, and for whatever reason, the town never formally accepted the dedication.
Right.
But once it goes on a map, it's a mapped street. It's sort of unowned. It's a right-of-way in favor of the public.
You make sense what you're saying. I understand.
Thank you.
Hold on, it's small and I'm slow.
The magnifying glass.
Did you see how small the print is?
I
And it's not your fault, it's because they have to be electronic, so everything's shrunk, you know. Okay, so the house on, the existing house that they're gonna, let's remove a portion of. That-
Yes.
That is then proposed to only be a one-story dwelling in the carved down.
It's currently one story, but we're gonna reduce it by 1,100 square feet.
Okay, so if, given that we're packing a lot into a small area, if we were to approve it, would your client accept a condition that another level not ever be put on it?
That it remain a one-story dwelling. Yeah.
So the
Yeah.
bulk,
Yes,
Okay.
no, I think we would not object to that. But if the board could do that in its discretion, I don't think there would be an objection.
Both houses.
well, you know, there's an argument
I understand.
made.
The proposed house is 2 stories.
Wait, I gotta get to that, hold on. So, and this, given that it's on the water, it doesn't have to do FEMA, right?
It's compliant.
The new house is FEMA compliant.
No, hold on, I gotta do one house at a time, I'm slow. So, the existing structure, since I assume, do you know what the VFE is there?
The existing structure, as deemed by the building department, does not have to be FEMA.
No, I understand, but what's the VFE there?
It's, I think it's 10.
Okay, so it'd be a 12 DFE. I can look at the other one and I'll know what it is. So in this house would be, they would agree to a condition that it never be, no story be added, with the caveat that if it had to come into FEMA compliance, it could end the FEMA level, but stay 1 story. I think that's a
Yeah,
fair,
if you added a second story, you would have to lift the entire house.
I understand, but my point is, I wouldn't want to say you can't add another level and then have the house need to be rebuilt with a FEMA level. You understand?
I
Mr. Brown?
understand perfectly what you're
So-
saying, yes.
Okay, so that's that one, and then, sorry, it's not that easy to find. Oh, by the way, Mr. Brown, I will say one thing. You know how much I respect your legal acumen, but I will say, as to your factual testimony, that I don't see that many 40s in the area. You know,
Well,
there's like
no,
6
no.
or something like that.
Yeah, on the street, I mean, but my point, I guess, is that Block Lane is kind of Block Lane. I mean, these other houses, it's their backyard.
Agreed.
The Island Parkway is sort of a different area
But
character.
even their front yard isn't forced, you know, like.
No, the houses on Island Parkway are on bigger lots, I
Right,
grant you
but
that.
that's all we have to go by, except this little block here.
Yeah,
And you're right, there's 1, 2, if these are, so other than these, there's 1, 2, 3, there's 3 40s and a 45, right?
Yeah, I mean,
I think.
if you don't count the subject, you have a 45, so 1, 2, 3, 4, 5. 5 is a 40 or 45,
Four
and then,
40s and a 45, right.
and then you've got 2 that are 60. And that's
Right,
Block
And
Lane.
on the flip side of the street. Okay.
Yeah, the flip side has larger lots fronting on Island Parkway, and I'm sort of saying, well, as we've discussed, Block Lane is sort of this unique, lane
But also-
fronting on the water. It's kind of its own little neighborhood.
So there's also something to be said, because, as you say, those are all these people's backyards. If we had, whatever, 7 or 8 60-foot lots, there's only 7 or 8 obstructions to the view everyone would like to share. Not to say they're entitled to it second off, but if we turn 7 lots into 14 lots theoretically, and I know that's not what you're proposing, now we have, it does change the character of that area, because now it's like a concrete wall or a blue wall blocking the backyards of everyone else. Again, they pay for a person on the water, I get it. But I'm just saying character-wise, I think there's
I understand.
Which
new-
drawing?
On the new house.
Oh, so
On the
I'm
new
looking
house,
at
yeah, it's
A1 of the new
Sorry,
structure.
it's an on-grade cellar.
Yeah, and that's the FEMA level, right?
That is correct.
Okay, and we'll get to, sorry, where's the, did you see us, Molly? I'm not criticizing you, but don't tease me about this thing.
That magnifying glass is valuable. Back in Arthur Levine's time, I used to think it was ridiculous, but I've since learned it's
But no,
quite
ever
helpful.
since we're- but-
I have learned to love
But,
it, yes.
Mr. Brown, ever since it's digital, look how big it is.
I know.
No
As long
one
as they don't catch on fire when the
Or
light
maybe
goes
hope
through
it does.
We never get sunlight in here. It's not a problem.
Sorry. So 4 bedrooms on the second, or the top level, right?
Yes.
Are they on, they're on sewer there, not septic, right?
I believe there's a sewer in the street, yes. I believe the sewer.
Sewer, yeah.
It's not a septic situation.
Okay. Oh, there's an attic? I didn't see an attic.
So unfinished.
All right, yeah, I just saw the windows.
No real access to it other than a pull-down attic access stair for the air handlers.
Yeah, I can't really
Primarily.
see what the highest point in the attic interior is.
It's,
Because it's fairly, it's like a 612 pitch or something. I'm just eyeballing it, but, It's got a bit of a
30,
pitch.
yeah, it's no higher than 30 from the crown of the road. We're no higher than 30 feet to the ridge as measured from crown of road.
Oh, really?
even
You'd
with the
think it would be
FEMA
from the DFE.
Right, I'm sorry. With
That's measured
the
from
FEMA
DFE.
house, they measure from the BFE. That's correct.
Yeah, but I wasn't actually asking for the exterior height. I was asking to see how usable that space could be. Let's say the house gets sold, and the next person decides, I'm gonna put some bedrooms up there. So I was just asking what the interior height was. Miss Adams had asked the same.
the attic
Yeah,
stand-up.
you could essentially stand. There is crossing collar beams that you'd have to duck under as you're walking through. But
What's the height where the flat part is, do you know? Because that's a 912 pitch.
it is a 912 pitch, yeah. If I had to guess, maybe the height's about 7. It looks like about 7.
Yeah, I think that makes sense,
Yeah.
because if I compare it to the 8 below,
Yeah, it's a little bit shorter. But there are structural beams that reduce the height in that attic to prevent the.
yeah, I see it.
Collar ties.
Yeah, I see it. But under the collar tie, like, at the peak, it's probably about 8 also, so at the collar tie, it's 6.
It's
Something like that.
probably 6 to the collar, yeah, I'd say so.
Okay, and so you're confident, Mr. Brown, that there's no 288 issue?
I don't think it qualifies for 288. It's the minimum 15 feet. As I've told you, my understanding of it as it's a public right-of-way on a map. It's not an unmapped street like a private driveway, which is really what 288 is intended for, in my opinion.
And Mr. Massey, you said the gate, the chain link fence gate that was installed, the one I saw, I thought was at the end, but this is going back to whenever that other case was here, or,
I'm not aware of any gate at the end.
but then the gate that, is there still the one that you said you thought was in the middle?
Yeah, it's still there, but it's like, strapped open. It's been that way for years.
Does your brother live in the maintained house now?
Yes.
And your mother lives there too, or?
No. My mother's in an apartment close by, but
Are you in the building business?
used to be, a long time ago.
Oh, is your brother in the building business?
Same thing. We used to be, but not these days.
Is your mother in the building business?
My mother was not in the building
Yes.
business. She's an immigrant from Czech Republic.
Is Mr. Reganis in the building?
How about your cousins? Grandmother, somebody else?
I can confirm that, that we would accept the condition proposed on the one story of living space on the maintained dwelling.
In perpetuity?
Yes, we will agree to that.
In perpetuity.
And I have nothing further.
Any other questions from the board?
I would move that the hearing be closed, the matter be placed on the decision calendar. Mr. Brown, you and everyone else who signed in on the case will receive a copy of the board's decision by mail once it is rendered.
Thank you.
Thank you, have a nice
Thank
day.
you, have a good day. All in favor?
Aye.
Any opposed? Any
Mr. Brown.
abstentions?
Can I ask you a local question? No, nothing to do with it.
No ex-party communications, Mrs. D'Amato. Lido Beach. Ah. Who do we have here?
We were racking our brains, we were talking about Swazi, and Swazi losing, and what I said, what part of that was distraction, giving the guy the other one.
Next case, 9124 Inwood, Jarvis Capital Incorporated. Variances, subdivision of lot area, front width from and on-street line to front setback line, lot area occupied, rear yard, construct dwelling with garage and wood deck with stairs. This is rehearing of case 148 of 2015,
This
east
case
side
was
of Chestnut Road, 35.73 feet north of Maple Road.
Oh, this is the, this is the.
I'm still under oath. Yes, I'm reminded I'm still under oath. I'm still under oath. Good afternoon again. Christian Brown, McLaughlin and Stern, 1122 Franklin Avenue, Garden City. For the applicant, as you just heard, this is a rehearing of a case that's quite a bit old. It was granted back in 2015. It was part of a subdivision where there was two homes were to be constructed. On your radius map, no, just, it was a two-lot subdivision. Two-lot subdivision that was carved out of the parcel that is now identified as 511, the subject parcel, and 510. The 510 house the subdivision was completed and a house was constructed. However, the developer was unable to construct the second home. And, yes. That's what the lots were carved out of. This was the second half of a two-lot subdivision that the board granted back in 2015. Subdivision was completed at Nassau County Planning Commission, and one house was completed as part of the subdivision. The second house was never completed, and the variances expired, and now we're back here asking you basically to reinstate them. Unfortunately, under the procedures in the code, these approvals were too old to be renewed, by administrative fashion, so we had to go back through the process. Yes, thank you. I would ask that this be incorporated with the original case. I believe it was under case, let me see if I can read these things. 25, I might need to, it's 2514 of 2014. And that, again, that created this lot. It's 52 by 100, 5,200 square feet. That was one of the variances. And then the house itself needed some minor relief for lot coverage. The house is proposed at just under 30% lot coverage, 29.82, where 27.5 is permitted. It's the same exact house. Yes, to my knowledge, yes, it was. It was CO'd and constructed, and so this house just never was. They never picked up the permits because of financial problems, and so the property is vacant, and now they're trying to finish it off after all this time. So the house is exactly what was granted. As I said, the lot already exists. It was created on the map. It's a 5,200 square foot lot. We need a rear yard variance, 20 feet where 25 is permitted, and a lot coverage variance, 29.8 where 27.5 is permitted. Those were the only variances, and we're basically looking for a reinstatement of the prior grant. There's been no other changes to the character of the neighborhood that, Yes, what's before you today is exactly what you approved back when. Yeah, no, the house, the lot, exactly. Exactly. You can see the old building permit number is on there. It's a 2014 number. This is the house that was planned to be constructed, that was approved, never was constructed. And again, because of the age of the approvals, we weren't able to do it the administrative way. We had to go back through the entire process. So here we are asking you to reinstate them so we can pick up a building permit and hopefully get this house built.
Is the already constructed house owner occupied?
That, I don't know if it's owner occupied, but I asked my client yesterday and he told me it was completed and it was given a CO.
I'm not clear on whether or not we did in 2015, but would your client accept a condition that it be owner occupied if we were inclined to approve this again?
On sale, yes.
Well, as long as no one occupies it before the
But,
sale.
well, it doesn't exist. It's a good point.
I know, but there is a
But-
point between construction completion and,
True. The standard conditions the board issues would be acceptable.
is there a basement? It's in wood, I don't know.
I don't know if there's a proposed basement or not.
Was there, excuse me, is this a FEMA house?
I don't think so. I don't
Because it
think so.
looks like 3 stories.
Let's see the plan.
1, 2, 3.
That's the already constructed.
Yeah, that's the already constructed one is.
Oh, I'm sorry. Excuse me. It is. It's an AE9 zone.
Okay.
It's an AE9 zone.
So the already constructed houses and your rehearing houses, they're the same structures?
I believe they're similar structures. I'm not sure if they're exactly the same, but they're similar.
But the one that's constructed is a big house.
This house isn't particularly big. You can see it's has a garage underneath, a deck, and its lot coverage is just 2% over. That's the only 29. Yeah. So again, we're just looking for a reinstatement. Hopefully, we can get this house built. No problem. Yes, that's all,
Brown?
unless you have other questions.
Any other questions from the board? Not, do I have a motion?
Move the hearing be closed, the matter be placed on the decision calendar. Mr. Brown, you'll be notified by mail, the board's decision once it's rendered.
Thank you very much.
Thank you.
Second?
Welcome. All in favor?
Aye.
Any opposed, any abstentions?
Next case, 689 of 23, Lido
Frazita.
Beach, Marie Fraziti. Special exception to maintain accessory structure trellis exceeding horizontal maximum with less than required side yard setback. Maintain pool waterfall with less than required side yard setback, also known as 66 Leamington Boulevard. Please be seated and state your name and address for the record.
Maureen Lewerson, 66 Leamington
Lido
Street,
Beach?
Lido Beach, New York.
And it's
Did you-
Christian
Can
Brown.
you repeat that? I'm sorry.
Maureen Lewerson, 66 Leamington Street, Lido Beach, New York, 11561.
And again, it's Christian Brown, McLaughlin and Stern, 1122 Franklin Avenue, Garden City, for the applicant. You can correct me if I'm saying anything that's not accurate, but my understanding of what happened here from the client's expediters is that a pool was approved and built here, and the pool contractor thought it would be a nice touch to add this masonry planter and trellis to the decor of the backyard, and
Do we want to know
family
who the
said,
contractor is?
go ahead, that sounds nice. And when the inspector came out to do the final inspection, he couldn't sign off on the job because you can see the photos that are in your file. They built this masonry planter and trellis against the side property line, so it triggers these variances in that essentially the side yard setback is
There you go, you'll like this.
almost zero there because the trellis is against the property line. And there's a waterfall, correct, that's behind the planter?
Yes, correct.
So it's a decorative structure. The trellis is, it's longer than what's permitted. You're permitted 12 feet, it's 14 feet. You're permitted a 2-foot setback, or required a 2-foot setback. This is, just a 0.33, a third of a foot off the property line. And then they charged them for another variance for this waterfall, which is set back just a foot, where they said 4 feet is required. So obviously, it would be a hardship to tear down this masonry structure. It's a very nice decorative structure. It's really sort of part of the pool, correct? And then the trellis is really just for aesthetic purposes in the backyard. I don't believe that any neighbors complained about the structure, correct?
Correct.
Okay, so we're seeking to maintain it.
No one's here today.
So there's an open permit for the proposed in-ground pool with fence. Is that being held up because of this waterfall structure?
That's my understanding, yes. That when the inspector came out, he said he couldn't close it out because of this structure.
Understandable. The rest of the pool has been constructed?
Yes.
And in your opinion, I assume that you're familiar with the building code regarding swimming pools and fence enclosures and alarms and all that stuff. Do you know if that's been installed?
The alarm for the fence.
Oh.
The safety
I'm
aspects.
not sure, but I would think so.
Okay,
The
yeah.
pool was entirely completed, correct?
Yeah.
Okay.
I believe it was entirely done, it was done to code, and it was just the addition of this structure that's holding it up.
Understood.
And the waterfall and the trellis are married.
Essentially, yes.
So as it relates to the trellis, can you just give me the number, because it has a horizontal,
Yeah, it's 14 feet
where 12 is
long, where
allowed?
12 is permitted.
And it's got side yard, that's the same side yard as the waterfall?
It's actually a little, they say the trellis is right on the property line, and the waterfall is a foot off.
No complaints from the neighbors?
Yes, that's probably it,
That's
That
the
would be it.
application.
that structure. It looks nice.
Can I see the
Yes,
picture?
it's nice.
They're over here. That's, it looks like this is the structure.
I have no further questions.
Enjoy.
Thank you very much.
Questions from the board?
Move that the hearing be closed, the matter be placed on the decision calendar.
Let's do
Mr.
it.
Brown, you and your client will receive a copy of the board's decision by mail once it's rendered.
Thank you very much. Have a good day.
Aye.
Last case, 41422 Baldwin, Naleni Moen. Construct 6-foot-high PVC fence on top of retaining wall varying in height from 4 foot 3 inches to 7 feet. Total height varying from 10 foot 3 inches to 13 foot, also known as New York Avenue. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do. Please be seated and state your name and address for the record.
Good afternoon.
Afternoon, Mr. Leeper. How are you feeling?
Not good. I'm
No.
scheduled for surgery on Monday after the Super Bowl.
I thought you had the surgery.
No, I haven't had the surgery yet.
Is it a secret surgery?
No, it's not a secret. I have 3 discs that are going to be removed and replaced in my neck, and
Oh, I'm at it.
3 vertebrae
5, 6,
that,
7?
pardon?
5, 6, 7?
Yes. And 7 is pushing 90% into my spinal cord, and I'm in
Join the
terrible
club.
pain.
Where are you having the surgery? What
Hospital
hospital?
for special surgery.
Where you should go.
Not Qureshi.
No, Dr. Sucumbi?
HSS on the island or HSS in the city?
Oh, no, in the city.
The real HSS.
Yeah.
I know, that's where I had all my, so I'm on a freaking
Yeah, I know. I went to Qureshi.
Could you please state your name and address for the record?
Yes, my name is Monty Leeper. I'm the architect for Mohan, and actually her husband's last name is Simangle.
Can you just tell me again the name of the surgeon? Because I went to Qureshi, but I wouldn't mind having another.
His name is Dr. I can spell it for you. It's a complicated name. Sucumbi. Let me, 1 second, I'll tell you.
Is this germane to the application before us? Oh, I see.
Yes, it's S-O-K, U-N-B-I.
You like him?
I think he seems very professional. I'll like him more after the surgery.
Depending on the outcome.
Thank you. So
Can
I'm
we
here
address
on-
the issues at hand now?
I'm sorry?
Can we address the issues at hand now that
Yes.
we've gone through just about everything else? Go on.
I'm
be
here
my
on
guest.
behalf of the homeowners who got a variance, it was granted, for a fence on top of a wall that at the rear of the property was the wall itself was as high as 12 feet, and the fence on top was another 6 feet. Toward the front of the property, forward of the house, I made the error of not including the 4 feet tall fence that sits on top of the wall that extends forward toward the road. It's an open picket fence. There are photographs for it. And it's already constructed. The same as the case before, everything was constructed and with a permit. And the building inspector has reviewed it, and this is simply waiting for a modification of the case in order to grant the resubmittal that we made to the case to the building department, and then the sign-off. The sign-off is ready. The
you
work
want it?
has been done. This additional portion of fence, 4 feet tall, as you can see from the photographs, without it, the drop-off when you get out of the car would actually be very dangerous on the driveway, and the owner constructed this 4-foot fence in the front yard, not realizing that it also was going to become a restriction. So an issue, yes.
Would you like to offer the photos and evidence?
Yes, I thought that they were already there, but I'm perfectly happy
Who
to
has
submit
them?
them.
Who has them? You took the photos yourself?
Yes,
and
I
they
did. Thank you.
Accurately depict what they purport to do? To depict?
They are accurate, yes. They were actually taken in the fall of 2022 because the work was done right after the building permit was issued in July of 2022.
We'll accept them into evidence. You can see them. Aha. Pray tell. Yep, take a peek.
I don't know if I have one. I've got a lot of papers. This is a survey. I'm just looking to see if it shows that. I mean, if, Don, if you want, they can use this. I'm looking to see if I have an actual plot plan. This was another survey, but this was before the work was done. And this one is probably earlier than this. This is 2016. So that's away. This is not the one that was submitted with the fence, but this is the plot plan. The fence is right here. It's 4 feet tall. Well, because of the drop-off, it goes from 5 to 7 feet. Do you have a pen? Yes. I think it has two different names, but, because I actually think it has three. There was also Second Avenue. Let me see. One second. For the,
Did one off of something. Of OpenGov. Of OpenGov, but it's unclear to me if that's in the file the 30 days in advance, but more importantly, the one that
we
she
can,
printed has no fence. I mean, this fence is up to 13 and a half feet high. This is a pretty significant fence.
well, one second, there is a set of drawings here. Actually, this is, yeah. Okay, this one's not sealed, but that was for my own record, but yes, this is, and there is a later submission. That's on the portal. I just didn't know I was gonna have to provide that.
Well, you wouldn't have to, but we're in the file. Also, it says, the one that I have, that you marked up for us, I think,
And I'll change that.
but even that, it says that all indications, oh, there is one noted, but like on one side, 6-foot-high stockade fence, on the back, 6 foot high. I will say on this side, 6-foot-tall PVC fence, 90 linear feet, total 11 feet, 3.5 from neighbor's side.
Right, and the drawing that you're about to see was part of the original submission for the building application prior to the zoning hearing.
Right, but here's so the reason I first wanted to see it, it says construct a 6-foot-high, is this a construct or a maintain?
Well, first of all, the 6-feet-high fence that we're talking about was approved already. That was under the case heard on, that was heard on June 8th of 2022.
If it's approved already, why are you here?
We're here because the 4-feet fence forward of the dwelling was not it was not mentioned in that case on June 8th of 2022.
Let me tell you what my calendar says while you're here. Construct a 6-foot-high PVC fence on top of a retaining wall, varying in height from 4 feet 3 inches to 7 feet, for a total height varying from 10 feet 3 inches to 13 feet.
That's incorrect.
Well,
And I have a letter.
see my confusion.
Yes, and I want to share with you this letter from October 12th, 2022, where I stated to Patrick Owens and to Robert Bogle the specifics of what this was. I don't know how that ended up.
In addition to this, how about this? The notes at the bottom of it say that the case is being reopened to clarify the height condition. It's adjourned from January 10th, I apologize, of 2024. These two things they're not even related. You're telling me it's a 4-foot fence. We're here to hear something that was adjourned from a little less than a month ago to clarify a height condition.
See this?
I don't know if it means the
I see
condition
it.
we're imposing or the situation being the condition of, about the height. Okay. Okay, let's look at that, but I don't even know where to start. First of all, what we're here to consider doesn't seem to be what you're here to tell us about. Secondly, the plot plan says the front street is Park Avenue, the address is New York Avenue, the radius map does say New York Avenue. Thirdly, the plot plan, if it were otherwise adequate, even if we were here for the high fence and this was here, those numbers don't match. It says that goes up to 11 feet. This says 13. Everything is not fitting up. And we don't even have a 4-foot fence that you think you're here for.
Additionally, you indicated that you're asking for modification and fence in the front yard or beyond the house, correct?
That's correct. The only thing I anticipated we were discussing today was the 4-feet fence forward of the dwelling that runs to the front of the house,
But
to
even this,
alongside the driveway. Nothing else,
would that
because
be
that
the-
was already permitted. It's already been approved, granted, permitted, and constructed.
Okay, So on the markup of the plot plan that you were gracious enough to write on, now I see why, reflecting the fence that you believe you're here for. You wrote near the house, at the front of the house, you wrote it's 7 feet tall. I don't know if that jives with what you thought was already approved. But again, that's 7 feet tall fence, but here, it's a 6-foot fence on top of a 7-foot wall. On
No, the
front.
reason I wrote 7 feet and 5 feet is because I have always understood that the height had to be taken from the neighbor's side. So the 4-foot fence with the drop-off of the wall that it sits on then ends up at 7 feet.
How
At the
tall is the
furthest
wall?
point from the road and closer to the road ends up at 5 feet, which
How
you can
tall
see
is-
in the photographs.
How tall is the wall?
Pardon?
How tall is the wall it sits
The
on?
wall varies because the land is
What does it
sloping away from the street toward the rear of the property, which is
What does it
why
vary from what to what, Rose?
I wrote 5 feet to 7 feet.
That's the wall or the 4-foot fence?
That's the fence and the wall.
So where it says 5 feet, you're telling me the wall's a foot tall?
Where there's, say it again,
Where
please.
you have written 5 feet tall, you're telling me that is, you're saying my 4-foot fence that I'm talking to you about putting there is 5 feet because the wall is 1 foot?
Correct. If you look at the photographs, you'll see that it tapers from
photographs
almost
will give you the
nothing.
numbers, though.
I'm sorry?
But the photographs, I'll look at the photographs, but
They're worth 1,000 words.
yes, but they don't have, they can't tell me the height. We don't approve like, oh yeah, let's eyeball it. But either way, that's not even what's before us.
Honestly, I know that that height will vary every time a landscaper comes and starts moving soil around.
This is completely, yeah. We gotta, I don't even know if it's an adjournment. I don't even know what we do because,
This was a modification.
Monty,
but modification, you said you're here for a 4-foot fence.
That's correct.
on
But
top of
that's
a,
not a modification of anything that's here.
Can I just want to explain to you that I went through a year and a half with Robert Bogle back and forth where he gave me his very long explanations and very confusing explanations as to how I should be
Obviously.
wording this.
Okay, what-
And here today
Monty,
is a culmination of whatever that transpired.
Mr. Leeper, I hate to be a pain in the neck, but what we have before us is not accurate. It needs to be clarified. I think it's in everybody's best interest for you to ask for an adjournment so that you can continue in the interim, get a very accurate
Plot plan.
plot plan.
And also, if it is a modification, work needs to be done there because I don't even know what we would be modifying. I mean, there's nothing I have here has anything to do with the fence forward of the dwelling. Maybe it doesn't, it's not described that way. It's all about this one that, as you say, this does seem to cover, if that's the same one, construct 6-foot fence on top retaining wall varying from blah, blah, blah. There's nothing that I could see about a 4-foot fence, and if it was a modification,
Exactly, because the 4-foot fence inadvertently was not mentioned in the original hearing, basically because I was not aware, to be honest, that the owner was planning on putting the 4-foot fence in, because he understood, from his perspective, that a 4-foot fence didn't have to go for a zoning variance. And I explained to him, after the building inspector explained to him, that on site with the fence already in place, the building inspector said, I can't sign this off because technically forward of the dwelling, that 4-foot fence was really 7 feet tapering to 5 feet, and that's why we're here. Not for the rest of the fence that goes to the back of the property from the front corner of the house, but only for the 4-foot fence that goes forward. And that was the conversation I continually had month to month with Robert Bogle for a year and a half.
The bottom line is that you need to get an accurate plot plan for us and show as you go along the different elevations or difference of the height.
and
As
if
we
it's a
go along.
modification, is this fence existing already?
Yes, the fence is in the photograph because it's already there. That's correct.
All right, the reason I ask is because if it's existing, at least it's not a huge deal to the applicant who might be trying to install a fence. That's the only reason I ask. you know, like if something's existing.
No harm, no
at
foul.
least-
Well, that was why I thought this hearing would handle that situation by simply changing the wording to make the modification. I was told that this had to be a modification of that case 414 from 2022 by this dialogue that we're having here today. I didn't realize
hold
that
on.
this would
So-
go further and further.
Even if we, let me just think, so this is a variance to construct a 6-foot fence on top of a retaining wall, varying from 10 to 13 feet, and level yard, whatever that means. So even if we accepted this as accurate, why would adding why would the fence now, you say you're before us, why would that not follow this description? I assume there's a reason.
When you say this description, which description?
Well, you're telling us that the fence already got approved. So the fence that we're talking about goes down that one side of the property, right? Right?
The fence is on the property line, yes.
On that one side. And it goes all the way down, okay? And it varies in height from
No, apparently it's
6 foot on top retaining wall, varying in height from 10 to 13 feet.
retaining wall
So
of like
if
2
we just
feet.
said, okay, fence is approved on that property line, varied, then why would you be coming back anyway for the 7 to 5? It would fit underneath it.
I was told that the 4-foot fence on top of the wall that makes it 7 feet from the neighbor's side, tapering down to the 5 feet, is forward of the dwelling and had to then be, by a hearing, added to the original case by
Well, it is
modification.
true that a fence forward of the dwelling is treated differently.
This is the
So,
fence here. He
in
says
the
we
prior
approved all of
case,
this,
was the plot plan showing the
but his
fence only
client
to the
built this.
front of the property?
It was,
to
it was
the
only
front of the
shown,
house?
it was only shown to the front corner because I was unaware that the owner was planning or inadvertently decided during construction to
Okay.
add a 4-foot fence because he must have looked at his driveway and said, oh my goodness, when we open the car doors, my children are gonna fall into my neighbor's yard.
Right, but so that wouldn't be a modification anyway. This is the approval of the fence in the rear yard. So even if that were all true, and it seems to be, it's not a modification of prior grant, it's an application for the fence forward of the
Blocks
dwelling.
both driveways.
Which is what I had originally thought, but I was basically told, and maybe Robert Vogel should actually have to appear to explain why I was told that by Robert Vogel that this is how he thought this should be handled. Because
It
I'm
doesn't
here
really
today,
matter.
I'm here today not because I insisted that we have the hearing as a modification. I was told this was the way it had to be done, and
Well,
I'm
but
doing
even
what I
if-
was told.
But even if that, I apologize if there was a misunderstanding. I would still couldn't do it anyway because we don't have an accurate plot plan.
Well, I'm going to now have to do my background search into the portal for each of these to find out what I submitted versus what came out on the other end, because electronically, things had to be sent in order for this to have gotten this far.
And Christina went off the portal that I'm not, I don't know if that's the one you submitted, but she pulled it off, and I think it looks just like the other one, which
Well,
doesn't have a fence on it that I can see. I mean, there looks to be something that might be a fence, but it's just. The one that you marked up, yeah, the fence stops there.
now, I marked up things that I had from my working file, not things that I submitted on the portal. I would have to electronically, I would have to send those to my printer so that I could then print them out.
Yeah, we
In order
just don't
to-
have them, we have the radius map,
Well,
not that,
I-
the ones we can try to get, we try.
What I've just learned from this is that from now on, whatever I've produced electronically, I'm going to have to bring paper copies with
That's
me.
not a
And
bad-
I
would-
didn't,
If it were me, I'd do that.
I'm pretty sure that the reason I don't have them is because once the case was closed the first time, I handed them to the owner. And I didn't expect to have to ask for them back. I don't
But
know
the-
if they
but the
blew away
case-
in the wind.
That doesn't make sense either.
Well, it does make sense.
The case was, well, the
It
case
does.
was but the case that was closed had nothing to do with the fence you're here today for.
That's correct, and I agree
So
with
why
you.
would that really wouldn't.
I
You
agree.
would have had to produce a new one anyway.
You and I totally agree on this. The fact that I'm here was because I was told this was the way it had to be handled. I didn't agree with it, but that's not my job to agree or disagree. I had to follow the direction of what I was given by the attorney for the board. Robert Bogle insisted on this.
But still, included in that had to be the submission of a plot plan showing the fence that you didn't apply for.
That's correct. And I'm sure that there is one.
Okay.
I'm not able to work with your computer here right now to produce one. I can't do
Okay,
that.
so let's
Do you want to
pick,
adjourn this?
let's
Is
pick a
that-
date.
Now, should I just simply submit a separate application and start this process as a fence application?
You don't do it now, we can call you tomorrow. And she'll figure out what the,
Because originally I proposed to do this as a fence
Okay,
application
time
and
out.
close
We-
this out.
We're beating a dead horse. What needs to be done is you submit a
plot plan.
plot plan and indicate on a plot plan previously approved, whatever that section of that fences are, so that it could be referenced to this. And what is before the board today would be that fence forward of the dwelling and show elevation, so to speak.
So I'm going to have two plot plans, the one that was previously
No,
approved
all
and then
No.
another one.
All
No,
in
no.
one.
Pardon? It could be all in the same one.
Yeah.
yeah,
Yeah.
here, fence under permit, whatever. New, whatever.
All right.
And then when you get your,
And then
when
how
you
does he
meet
get the
with,
wording to be
when you meet with the office, you're gonna ask for only that portion, 4-foot fence, varying in height, forward of the dwelling,
That was not
period.
previously approved.
Because this is already a done deal, the other stuff.
Yeah, I mean, you're right, you give us a paper. What we have before us is what's already approved.
Yeah, I apologize. I didn't expect I was going to be handing these things in. I would have come with the latest
all right.
things. I had
It's
no
okay,
idea.
Martha, you got a pain in the neck.
Do we want to set a date?
I do.
April 17th at 11 o'clock,
Well,
You have
let's
enough-
see what his medical,
May
Yeah.
1st.
By the way, Mr. Lee.
You know what, why don't we set April 17th as a control date? How about that? And hope that Mr. Lieber will,
17th, he'll be fine a week after his surgery. Fine by April. I did it. I had back, neck, did it all.
I hope you're right.
Oh, believe me, you probably won't even have, I didn't even wear a collar home the day after surgery. 3 levels.
we're going to set it for April 17th and hope that you can,
April 17th
yes.
at
You'll be going like
2
this the
o'clock?
day after
2
surgery.
o'clock.
11 o'clock?
11 o'clock? Fine, 11
yeah,
o'clock.
I'm
Is that
telling
okay, Mr. Leeper?
I'm putting down 11 o'clock.
Good.
Mr. Leeper,
Yes.
a day or two post-op, you'll be like this. I'm not
They're telling me I can't even drive for 10 days.
Oh, they always say that. Listen,
Run around the block the next day. That'll
no,
be
but you'll
great.
be surprised. The other thing is, when I said to you that it was adjourned from 1/10/24, and you didn't recall that, now that I think about it, I think someone came in. Were you in the doctor or hospital during that time? Were you injured?
Yes.
I think we did call this case on 1/10/24.
No, it was a case for a subdivision in East Atlantic
Okay.
Beach, and it
Okay,
was,
so I don't know why we think it was adjourned from that date.
Mr. Chairman, I
thought
move
that
the hearing
that
to
got-
close the case, be
was not
adjourned
that
till
case.
April 17th at 11 a.m.
Second? All in favor?
Aye.
All right.
And honestly, the reason that got adjourned, but candidly off the record at this point, in January, was because the attorneys were so confused by the notification and all the other paperwork that they had to take care
Oh,
of.
is that the Brooklyn case, the triple subdivision on Buffalo in the land? Oh.
Yes, and they wanted me to do it, and I told them I wasn't in a condition to do it, and so they had to ask for an adjournment.
Yeah,
because
that's right, they said you were.
I gave them full instructions on what needed to be done. I don't know how many times I had to tell them.
Isn't it
still
wonderful
didn't
to
happen.
feel necessary?
Pardon?
Isn't it wonderful to feel necessary and loved?
I'll remember that in my retirement.
Are you
Okay.
getting general or sedation and block?
I'm sorry?
General or sedation and block?
Oh, I'm not going to be awake for this.
No, but sedation and block isn't awake. You wouldn't know it except you don't have a vent. Like you go to sleep and wake up the same way, you wouldn't actually know if they gave you sedation and block. It's not like a colonoscopy. It's like sedation and block is, from your perspective, you wouldn't know if you had general or sedation and block except
Right.
for 2 reasons. You wake up without the throat problem from the vent,
Oh.
and number 2, you can have a little more water in the morning before the surgery.
Well,
Thank you,
my
Don.
discussion with the doctor was that he didn't guarantee I would wake up. He said that there's a 3%
boy.
chance of not waking up.
Yeah, if you
What is,
will-
what did you say? There's a what chance?
He actually said there was a 3% chance of not waking up.
He has to say that.
When you get sedation
Mrs.
of block,
D'Amato is
they'll
actually, she's such an expert, she's going to be your surgeon. They didn't tell you that.
No, but when
She'll
you
be
get
in
sedation of
scrubs.
Well, I
block,
don't know
they
what
can
you're doing
wake
for
you
the
up.
Super Bowl, but
and
I
you're
don't
going
want
out.
you doing surgery if you're going to be drinking
Okay.
at a
Listen,
party.
when you get sedation of block, as you're finishing surgery, they can stop the flow. You'll be like waking up when they wheel you out of the room. That much.
I have a place to go.
Well, that'll be
That's a good
interesting.
place. They have ham and turkey
Well,
sandwiches.
I've already had surgery there. I had a hip replacement, and I've had my knee redone, so I
I'm
trust that.
literally a frequent flyer from, I still know all the guys in the garage. I go, could you keep it down? I give them an extra $5 to keep it down. I had so many surgeries from the garage, like 14
Steph,
surgeries.
are you finished? Okay.
Did you get all that down?
Can we please?
Oh, good, thank
can-
you.
can-
Second,
Right?
All in favor? Any opposed, any abstentions?
you'll be surprised how you'll recover fast.
90-second break, and then we'll come back
You'll
and
be
do
surprised, I'm telling
decisions.
I'm trusting that you're right.
89, 88,
will.
Good luck,
87,
Monty.
86, 85, 84.
Wow, I didn't get one of those.
Well, you're not handicapped like he is.
No, he's getting it for one neck surgery.
It's, you know,
I had one neck surgery and two back surgeries.
Two-
I'm just saying,
two
you know,
chicken
one
necks,
surgery.
a
Not
duck.
one neck, one surgery. 5 shoulder surgeries.
She'll come in and watch. I didn't know I had 23 vertebrae. You gotta let me know whether or not.
Oh, God. So when's your anniversary, Joe?
what's that?
When's your anniversary?
Wedding anniversary? June 5th,
Oh, ours is June 20th,
1971.
1971.
I was a baby.
I was a baby. I was too. I was 21.
So was I. Yeah, they don't even do it
Different
now.
21
Oh,
than
yeah.
I was. Oh, my God.
Boy, oh, boy.
Maybe she can go with me. I thought this is supposed to be short today.
Let's do it.
Let's go.
Let's do it.
Let's make some decisions, all right?
Couture absent for vote.
Okay. Cases 86 through 88 of 2024 East Meadow, Merceda Ibrick, and Ravi Baldeo. Do I have any discussion? If not, do I have a motion?
I said hold for some reason. What are we holding for?
Yeah, we're going to hold that.
Well, what,
Yeah, updated plans.
oh, updated plans? Is that what we were waiting
Hold
for?
for seller plan.
Oh, okay, fine. So we're holding
Where's
that.
Christina? Let's wait for
86 to 80.
Solar
Oh,
plan, okay.
okay, Christina.
Case,
Hold.
where did Grace go?
Where's anybody?
Let's not prolong the agony
So
here.
Christina, on the first one,
We're going to hold
we
it.
all have hold. I have hold
Seller
for
plans.
Yes, the
Yes.
amended plans is your basement.
Okay.
It said need to file app to legalize. I forget if he said he already did it or not. I don't think it's legal. That's right. So I don't wanna, that's right, remember? I asked him to let us know. I wanna know that he filed the application, not just give us the plans, give us a copy of the application that he filed to legalize that seller before we approve this case.
All right, so we're holding it.
All right. Next case. Case 89 of 2024 and 90 of 2024.
Can we hold that on?
Subdivisions, we'll hold those bad boys.
Should've kept the papers out.
Okay,
Just have the,
yeah,
site plan, radius map.
yep.
But not now.
Case 91 of 2024 Inwood,
You can get that.
Jarvis Capital.
Record this, right?
Yeah, you can get it after.
What are we doing on that? Any discussion?
That one I was fine with.
Yeah.
It's got to be owner occupied,
Yes, that's
usual
what I wrote, owner
subdivision
occupied.
conditions.
And it's approved, in connection with the plans that were originally approved and no changes.
Okay. Case 92 of 2000,
Who made the motion?
oh,
I
What?
thought it was Kim.
Oh, me?
yeah, make a motion.
Okay, wait, hold on. I
Kim.
make a motion to approve case 91 of 24 in Inwood Jarvis Capital, located at,
No address.
yeah, Chestnut Road and north of Maple Road.
Usual
Usual
Usual sub,
subdivision conditions and include the prior hearing case.
And owner occupied.
Owner
owner
occupied,
occupied,
yep.
offered by the applicant.
Yes.
Approved as depicted on the original plans.
In connection with case 14815?
And, yes.
Yep.
And I guess we should confirm that the plans filed for 9124 are consistent. Sure. Like compare them, so we don't have,
Okay.
Second,
All in favor?
Aye.
Any opposed, any abstentions? Case 92 of 2024 was adjourned to March 27th, 2024 at 2 p.m. Case 93 of 2024 was adjourned to April 17th at 2 p.m. Case 94 of 24 was adjourned to April 3rd at 9:30 a.m. Case 689 of 2023, Maria Frazzita. Any discussion? If not, do I have a motion?
I will make a motion, Mr. Chairman, 689 of 2023 Vito Beach, Maria Frazita, that's in the property located at 66 Lewington, I think it's street, it says Boulevard, that it be approved as requested,
No, it's west of Leamington Street.
Yeah.
usual pool.
It's on Leamington Boulevard.
To the extent there are
It's waterfall.
waterfall
That's
conditions.
waterfall. Usual trellis conditions
And
also.
pool waterfall. Second, anyone?
All in favor?
Aye.
Any opposed, any abstentions? Case 414 of 2022 has now been adjourned to April 17th at 11 a.m. Okay. It'd be a good idea if I had the reserve calendar. What the hell did I do with it? Why do I have this? Wait. I had notes on some other ones. Okay, thank you. Okay, thank you. Anything on, let's see. Did we get anything on 199?
Nope, we are still waiting for Junior John.
Okay.
Why don't we tell Mr. D that we're gonna decide the case?
Why?
I
We
mean-
need to rush it.
It's taking space.
No.
No, I don't care, it's just,
It was a thought. You just like to,
yeah, it was just,
yeah, I
I
know.
just like to talk,
You want to be that way.
like my buddy.
Okay. Cases 365 through 368, they so we have to wait, right? They filed for sprinklers with the fire marshal. 503, spoke to HA, told them to see if client, go ahead.
So I spoke to Mr. Abertin actually this morning, and he has a meeting scheduled with his client and the architect, and they are going to see if they can come up with maybe a resubmission of new plans that,
Reduce.
that reduce the size of the.
A lot are occupied.
Okay.
And he did agree that he'd give us more time than 60 days.
Cases 784 and 785, is there a reason to continue holding this?
Every hearing and
So my,
testimony said everything was identical as previously.
Yeah.
I don't know why
Wait,
it's on hold.
Christine has.
I don't, know. That was my question.
so
I didn't know why that was on.
Mr. Brown was speaking with the neighbor's son, and I actually spoke to Mr. Brown, and there are no issues that remain
Okay, so do we have a
Son about,
about the proposed project.
subdivision?
was he against it?
He was
Interesting.
interested,
Yeah.
So he was answering the community's
correct,
concerns, that's been done,
correct.
and,
He's a friend of Valenti, and he said, I withdraw my opposition at the
oh,
hearing."
that's that one.
Yeah.
Yeah,
All right, so is there any reason that this is not?
what, yeah, it's taking up space. Can we have a motion on 784,
Okay,
785?
784, 785 in Seaford, Ricky Valenti, the subdivision It's a rehearing of case number 295 and 296, that it be granted with the same previously imposed conditions.
And
Second?
Second.
Did you want to say something? I didn't want to
No, go
interrupt you.
ahead.
All in favor?
Aye.
Any opposed, any abstention? Okay.
For, the next case, 786, I did circulate a draft.
Oh, yeah. We should have read the first one.
I will make a motion, Mr. Chairman, as it relates to case 786 of 2023 in Windermere. Emily Fuchs, affecting the property located at 547 Fairway Drive in Woodmere. I move that as it really, oh, there's only one case number, so I move that it be granted in part and denied in part. I move that as it relates to the request for a height variance and a variance exceeding the number of stories, that request, those requests be denied, and that we otherwise we grant the request for lot area occupied, side yard aggregate, and constructing a dwelling with a garage. We grant that and adopt the decision granting that dated, I'm not gonna put the date, dated February 7th, 2024.
What was the lot area occupied?
Me neither.
If it was huge, we don't want to grant it.
Well, they're gonna need it since we cut a whole story off. We can pull the file if you wanna see it.
It'll be granted so long as it meets code compliant. What the board is gonna do is just grant a lot of area occupied, right?
And the side yard
For what?
to construct a dwelling that doesn't have 3 stories and doesn't need a height variance.
So it would be dwelling minus height.
Yeah, like, for example, if they redesigned it and it needed rear yard, they have to come back for rear yard. But if they redesign it and they can do so with lot area occupied of, okay, I get, take your point.
Thank you.
I'm gonna amend my motion to say, I move that we grant the lot area occupied side yard and side yard aggregate that were requested, right? So if they stay within those parameters, if they come back with it, if they go to the building department with a house that doesn't need stories or height, that has the lot area occupied, they already proposed, side yard they already proposed, aggregate they already proposed, then they will get it, they will be able to get a permit to
Right.
construct such a dwelling.
But it has to be, just like you said it now.
I do it already? No. You want to do it, Joe?
No, it doesn't matter. Go ahead.
Okay, as it relates to case 766 of 2023 in Hewlett, Broadmoor LLC, affecting the property located at 1185 West Broadway in Hewlett. I move that the board adopt a negative declaration as it relates to the secret determination based upon the materials in the file, the testimony at the hearing, and all other review that the board members and/or their representatives have made. I further move, Mr. Chairman, that the board grant the request for a place of public assembly as a proposed automobile museum and a variance in off-street parking, that we grant that request as it relates solely to the use proposed in this application, and that the board grant it for a period of 5 years, and adopt as part of that grant the draft grant not just the draft grant to the board. Yeah, it's there. Oh, that's yours, I'm sorry.
I move that case 11 to 14, 2024, in Wanto, Mario and Meredith Racinos at 1300 Holiday Park Drive be granted as requested.
Wait, but what about?
Wait for what?
Yeah.
And rear yard setbacks. The applicant at the hearing testified they would be moving the shed, which would alleviate the need for side and rear yard setbacks.
There you go.
Okay, so sense of that, I second Joe's motion.
Aye.
Abstain. So wait, this Ms. Reardon, wait, so they request a special exception to maintain the second accessory structure, the shed. The lot area
Yeah,
occupied,
no,
less than
you
the
should.
sidebar set, right, but. Wait, you want to deny? Deny it. Roof over,
Yeah.
wait.
There's roof
Roof
over
over
and exterior basement stairs. So
And the
if
roof
the
is over those
is
stairs?
over the basement
Yes.
stairs, what is the reason for
I agree.
granting to maintain the roof over?
Can make a patio out of it. There is no
Oh, wait
reason.
a second. Okay, that's the other one. Yeah, okay, I agree with you.
Go for it.
But I can't make that motion.
Wait, you want me to do it? Okay. Oh, okay. All right, Mr. Chairman, I move as it relates to case 18 of 2024 in Uniondale, Guillermo, Ramirez, Soriano, Matria,
Yes, yada, yada, yada.
Ramirez, and Villa Herrera. Affecting the property at 361 Green Grove Avenue, my eyesight's so bad, in Uniondale.
The-
I move that we
The nuns told me about that.
deny-
That would happen.
deny the applicant's request for a basement staircase with a roofed over patio.
Second.
Or roofed over.
Aye.
Absent in hearing.
You were absent? Read the minutes. Case, what do we have on?
He's got better things to do.
We do. Actually, at the last hearing, the applicant did submit the plot plan, and we did confirm that the permit number on the plot plan was for the pool.
But did it show that, didn't show the pool though, did it? Or did
They
it?
submitted a new plot plan with the pool, with the permit number.
Perfect.
At the last one, you wanted me to make sure that the permit number wasn't.
Good, okay. I move that case 2627 of 2024 in Seaford, David Coletti at 3888 Ralph Street in Seaford be granted with the usual pool, no, it's already done. Granted as requested.
Second? All in favor?
Aye.
Any opposed?
Absent in hearing.
Was absent.
I didn't look at the next one.
So, what, participate?
We should not be doing these.
NVNP.
anymore because of changes.
Which one?
That's the renewal. Yes.
Oh,
So,
It's,
no longer need them technically.
which one?
did we use to?
T-Mobile?
We did, but
Yeah.
we did them.
Yeah, the feds are after us. Case,
You gonna recuse yourself? Husband not allowed you?
I have no idea, I'm not recusing myself. I have no government.
case number 34 of 2024 in Roseville, T-Mobile North East LLC, renewal of grant to maintain the pole. It's at 230 North Brookside Avenue in Roseville. I move that this case be granted permanently with what other conditions were imposed by the board.
Second. Aye.
Mrs. Donato, with due respect, 29 and 40.
Mull with me.
I did not.
Oh,
I'm trying to remember the case, just let me think. I don't think I did, but I don't.
I think, yes, this is the one where, is it 5 Cook Street? Yes, this is the one where it was a ridiculous lot area occupied. It was
Oh,
a teeny tiny
like
lot.
59%?
Yes, and there was an issue with non-conforming findings, remember?
Oh, yes, and I was,
So we have an update. Okay? The plans examiner has submitted an amended non-conforming findings.
yeah, this is the one we went over, right?
This was the original. And I think the issue was.
I know, I remember. Is this one he wants to move his daughter in or something, she's pregnant?
Yes, I believe that is it. It's super, it's like 15 feet, yeah, it's crazy.
20, it's like a 20.
Yeah, it's very interesting. So I think the takeaway is that they would not lose the non-conforming status if they comply with one or the other.
Who asked for a update or a modification of the,
I was
Ms. Pangaro actually reached out
Oh.
to the plans examiner at Ms. Mano's.
Because there was something, it was not, it didn't make sense.
Mhm.
So, Christina, at the end of the day,
this is it, we're here.
The issue was that they didn't want to raise the house, right? But, yeah, they didn't want to elevate the house, but how the conditions were initially written, it was a little confusing. Because, this is not changed, as long as the
Yes, I remember now. So
So-
it seemed to say, if you didn't elevate it, you don't have it
A CO.
non-conforming.
And you
Yeah,
don't
I
get a CO.
remember.
But
It was
now-
Becky, I remember now.
But now it's obtain a building permit for the repairs of storm damage. So my suggestion, if the board's inclined to grant this, would be that we can impose this as a condition.
Well, all those are conditions, right?
They are, but if you want to add it again,
Okay.
Send it home.
I'm down with that.
you know, see it twice.
And
instead of once.
otherwise,
Can I
it
see
seems
what
like
it
an
is?
okay case.
I thought, I mean, it was a very unique lot, so I don't think that us granting a
Tennessee
case
law.
of a high lot
No
area.
precedential impact.
Correct, I mean, you're not gonna find a lot like this.
Yeah.
And it's.
Yeah, I completely remember it now. It said, if you want your non-conforming, you gotta do these things. And he never did that thing. He never elevated the
Correct,
house.
and then it's, ooh, what happens?
Yeah.
There's no way that you can build really anything on that house, even a shed. You know, it's a tiny lot.
So, shall we move to approve it then, with the, provided that the conditions are met?
So that,
The conditions of the non-conforming, I'll incorporate this.
but it's still gonna be a 59% lot area occupied or whatever it is?
If the board grants it.
Can we make some condition
whatever,
that there
it's-
shall be no
keep on, you know,
further
blowing-
expansion of the footprint and/or any accessory? There should be no,
You didn't get a
no
chance yet.
change to the property that increases the lot area occupied, including but not limited to accessory structures. Can we do something like that? Because it's already 10 pounds, you know what?
No.
Huh?
It keeps on blowing and blowing, bigger and, you know, we're blowing up the balloon until it pops.
I agree. I don't like it either.
So, we don't do it.
And again, going forward, all of these conditions, those two that we mentioned before, will be in it, so.
Well, I mean, the distinguishing characteristic we can use is, it's a legal, it's a non-conforming, so, I mean, that gives us a little something.
If it's a non-conforming,
Here we go, this is exactly what gave rise to it before.
yes, it's a non-conforming.
Why do we have to?
Why do we have to say, yeah, we're gonna grant you 59% lot coverage? Let the goddamn building department do what they have to do.
All right, I'm down with
Why
that.
is it that we have to do this? Because now
Let
we're
me
gonna
look
set
at
a
it.
precedent.
Right. Exactly.
I don't disagree,
59%?
I don't disagree.
Let them deal with it.
So why, well, let's
No.
go back, no, but
Why
let's.
don't we push it
Okay.
off to us?
I understand, but
So that
leaving,
shows
leaving the
59%
rhetorical and
lot
actually
coverage
answering the
is
question.
That's,
Why is it that they, what part of this are we granting?
we're gonna deny the
No,
whole
what
case.
part of it are we asked to grant? I know that sounds like a stupid question.
First, they turn around and say, oh, it's pre-existing non-conforming, that's great. Then go out and get a CO for this, get a CO for that, get a CO for that, and kick it over to the Board of Zoning Appeals so they can make a determination that we're okay with 59% lot coverage.
Okay, so what, we are been asked, lot area occupied, front yard average,
The only
side
thing
yard, side
that
yard,
was
rear
clear
yard,
that
maintain
was
addition,
Legal,
and
was
decks,
what was
all
there.
attached.
Yes.
why do we have to expand that?
Hold on, let me ask something. If we denied this matter, we would deny an addition, a bunch of decks,
Yeah.
all decks,
Yeah.
hold on, a shed, so we would be denying a shed, the decks, and an addition. If we denied that, I don't know if
How
that,
much space, let me ask you this.
what would be the lot area occupied if we denied that?
We
I don't-
denied the decks and the shed. What's the lot area occupied?
And the,
Grant
so
the
grant the
building living
addition,
space.
all right,
Who told them to buy the house?
Everything is, by the way, maintained, it seems. Maintain addition and decks, attached dwelling. The additions are.
well, let's start by the shed bit now.
Can I ask, can you hold a conference with the idiots in the building department?
Sure.
And say,
I'll speak to Becky.
putting us in a
Yeah,
bad
she
spot.
knows her stuff.
Sure.
Because we're not inclined to grant
Sure.
it to 59%.
So we could carve
So
out
would I.
the
What
shed,
you clowns do
yeah.
to minimize the adverse consequences.
I mean, we can carve out the shed, and it says decks up. So,
That's because they can remain as illegal as
Can,
no, but I'm saying.
let's take a vote.
No, I'm saying, if we carved out the, if we didn't grant the shed and we didn't grant the decks, right? And we granted only the addition living space.
I don't know.
mean, I think, that I
bought the house.
like that approach.
You,
And then they
like
can
a
come
big
back and
old
go, well,
house
can we
that's
just
gonna
have this
require
one deck, 'cause
maintenance
it's not
over
really
the
a
years
deck, it's
'cause
our
it's
front
old.
porch.
That's
How
fine.
big- how big
God
is
bless
the
you. It's-
I don't recall, would you like,
I'd like you
for
to
next
talk
week?
to her.
I'll speak to the plans examiner and we'll make sure to bring the file next hearing, which is next week. Okay?
Oh, Gracie's last day with us.
I will be wearing red, I'll be wearing red
I'll
pants.
forget, you know, I'll forget.
We'll remind you. Okay,
Yeah.
so we have an update on 41 and 42. I was asked to get the original plans because there was a cellar entrance.
I might.
Oh, that's the one in the back, right?
Yes. So, what I found, the plans from the 1960s when the house was constructed, which by the way, it actually was another daughter for quite some time, they do appear to show that there was an optional cellar entrance.
What is that?
I have no idea, but
It means that they're standard plans for the development in the neighborhood probably, and you go and pick, oh, I want this, I don't want this, I'll pay extra for that. I'm guessing.
One developer for all of them.
But to make things even more confusing, so while it is depicted on the original plans as an option, I did find an old survey from
Yeah, but-
1967, and I do not see a cellar entrance on it. So,
This is 41, 42?
41, 42, but to make things even
It's not
more
before us.
confusing, if you try to match these up, you're gonna see this is where the front porch, the staircase for the front porch, it's reversed, it's flipped from
But-
that, so I don't know what that is, I don't,
Wait,
But that's, none of that is before us.
we don't have a cellar entrance.
we don't, but the board asked that we pull the original plan.
Does it mean, did I do it or did Joe?
I don't know.
Oh, Joe.
What do you call
But
it?
so on the plans, it does show that it's optional, but again,
Well,
the plans,
that's meaning.
So I don't need to inspect this,
The
because
survey
that is.
controls. It shows that it wasn't there in 67 on this particular home. So
And-
have you waited it, folks?
Is
But-
there,
but it's
is there a
not
permit
before
for
us,
that?
So what do we do?
Is there a permit for that cellar entrance?
I,
Well, there you go.
yeah, I didn't.
See you next week.
When did we get sidetracked on the cellar entrance? That's not.
Well, it's Elmont, probably Kim.
Nobody uses it. She doesn't even know where I'm on.
You took her there once, I think.
Yeah, for a very short.
Yeah, I
period.
did. Get me out of here,
Wait,
John.
are you sure that,
It's this.
Chairman?
Hit it, buddy.
The chairman says you take a vote on the immediate family residence and six building.
All right, Mr.
And
Chairman,
violate them if that's an illegal basement.
what about the shed?
Make a motion,
Microphone.
what?
Mike.
I make a motion on 41 to 42 of 24 in Elmont Henry Lap, located at 300 Keller Avenue, that we approve the immediate family request.
And a shed.
Second?
And, second?
Shed.
What about, and the shed?
Shed.
Second?
Yeah, what,
Aye.
shed conditions? Shed conditions.
Shed conditions, not habitable space.
Said shed. 44. for reopening and explain that the plans are 6 inches. We'll vote to deny the request to reopen it. I literally moved my.
I make a motion on cases 62 of 24 and 63 of 24, Roosevelt, 146 East Pennywood LLC, that we request the, that we deny the request for the subdivision.
Anybody want to second that motion?
Second.
All in favor?
Aye.
Any opposed, any abstentions?
So, Mr. Chairman, revisiting case number 76 and 77, 2024 in Elmont Webb and Modeline, Casimir, affecting the property located at 312 Randall Avenue. I move that we grant the mother-daughter application with the usual mother-daughter conditions, and that we grant with the condition that the second meter on the house be removed within 60 days. That we grant the request to maintain the awnings attached to the dwelling. And that's it, yeah.
And Christine will
Yeah,
make a
that's separately.
We have a second?
In favor?
Aye.
Any opposed?
We have a motion?
Motion
Make
to
motion to
adjourn.
What did we ever do on that one?
Any opposed?
What did we ever do on that?
They're coming back.
Yeah.
Oh, that's right.
Who's coming back?
3:27 at 9:30.